agency requirements such as DTSC, you know, and so it's hard teasing out our costs of compliance. We go.
One thing just to point out, when we presented the work plan last year, one of the areas in particular that we did overtly exclude from this Phase 2 effort were, for example, municipal solid waste landfills regulated under Title 27. So there were certain types of activities that we said for now we're going to pull out. But the WDR group in particular has a very challenging task because of the diversity of facilities that are regulated through that tool.
Yeah, no, I really respect that.
Excuse me, Mr. Moore, we do have two major waste managers involved in this thus far. So.
Waste Management has attended the meetings, Waste Management Inc., but again...
That would be one, yeah.
Yeah.
I also wanted to comment on something Emily said about some people expressing concern about the June timeframe being unrealistic. Well, I always shoot and push for people to do things as quickly and as efficiently as possible, but I think, you know, it's pretty obvious today that we've got groups in multiple levels of progress. And while I certainly hope that we will still keep the June deadline in terms of presenting some, you know, recommendations to the board, I don't necessarily expect that, you know, all the pieces will be in place by June. I mean, I think the discussion today has been very helpful. I think the work that you've all been engaged in will lead to some good, hopefully, recommendations that could be implemented in the short term. But I think, you know, there will be something that will need more fleshing out, more development, more discussion. And so if, you know, what you're able to present to us in June are foundations for continuing work, I, for one, would be extremely grateful for that as well. So I, you know, at this time, I'm not suggesting that we back away from June in terms of getting recommendations to the board, but realistically, I think we all recognize that there will be groups in different stages, and the recommendations will be in different stages. And if there is, you know, to be work to continue forward after June, I certainly expect that as well.
Yeah, and I appreciate those comments, and I couldn't agree more. It seems to me, particularly with the list of short-term potential issues, we could certainly get maybe some of this knocked out by June. And for the others, you know, yes, I like your terminology here, foundation for ongoing work, and certainly there will be quite a bit of that, I'm guessing. So just by the feedback I've gotten. So by all means, yeah, we're on board, and I'm going to try to encourage those to still participate in the process. But yeah.
And I think we've heard from at least Jeff and Emily today that, you know, the fees issues are still coming up. So as much as Karen would like to have a clear distinction between phases 2 and 3, I would expect that at some point later on this year there will be some mingling of those two phases. And
I would also like to point out that it's at the beginning of 2013, and we will, some months hence, begin the annual meetings that we pull together of our fee stakeholders, water quality and water rights, and they will have yet another opportunity to discuss approaches within the context of the budget that we're moving forward for the year.
I cannot wait. I'm sure they can't either.
And remember, that is the reason for the June deadline, was because we did know that this was coming up. And so the more you can get done by June, the farther you are along the way, the more useful you will be in engaging in this phase 3 conversation. So,
and at the risk of doing something that is extremely frowned upon, which is getting ahead of the governor on budget issue, let me just say that if staff is thinking of bringing forward recommendations for fee increases, please don't.
That seems highly unlikely considering the nature of the governor's proposed budget at this point.
we have one, I have one blue card. Bruce from Sac Valley Water Quality Coalition.
Introduce yourself. Madam Vice Chairman. Am I close enough? There we go. Bruce Halderschelt, Northern California Water Association, which represents the Sacramento Valley Water Quality Coalition. Couple of thank yous. First to Danny Merkley. I swear, Danny Merkley was 6'1" when I first met him. But he is involved in so many things where people tell him to go charging headlong into processes, that this is what we have left of Danny. And I appreciate his comprehensive summary earlier today. I want to thank you, though, also for this process, which began in 2010 when there was a shift in the governor's budget, and you had the unenviable task of figuring out where those dollars and cents were going to go. And the irrigated lands fee went from 12 cents an irrigated acre to 56 cents an irrigated acre. That was a shock to the system. I'm going to give you some real numbers because I think that's important. You've got the state water quality fee at 56 cents an irrigated acre. The Sacramento Valley Coalition goes from Solano and Sacramento County in the Delta to the Oregon border. We have about 8,500 irrigated acre, farming operations enrolled, minus rice. Rice has their own coalition in the same geographic area. We have about 1.2 million acres on a fairly consistent basis enrolled in the program. So from a programmatic side of the world, our budget annually is, with everything, is roughly $2 million. The fee on top of that, by the way, when it went from 12 to 56 cents, went from about $145,000 that growers pay to over $600,000. And I think that's about 35% of all of the money that's collected as part of that fee program. And I think Danny did a good job. There are fees you can quantify. There are numbers you can quantify. And I should go back to something Emily said. This is more about right sizing. This is not about not doing the right thing in the way of stewardship, in the way of water protecting surface and groundwater quality. And I think Emily's point was right on. This is just right sizing it. So we've got 1.2 million acres. We get the bill. We pay our $650,000. I'm going to leave this with you. This is something we put out. We'll put out again in a short period of time, but it's a summary of our water quality results. 97% of our surface water results for pesticides below detection. One sample out of 170 toxicity, both aquatic and sediment, one was related to agriculture. We don't rest on those results. As Danny indicated, we're going into a new program. As you know, there's a new program for irrigated lands that will be involved in groundwater. We're actively protecting the Sacramento Valley surface and soon groundwater. The other thing I think a couple folks mentioned. So let me go back before I forget this thought. So, and I've heard Board Member Dodak say this on occasion, and others, and I heard it today. When you have those kind of water quality results, do you need to be sampling monthly? Do you need to be doing that kind of a program? We've had some success, and Danny alluded to the swamp, where one of my folks said, hey, how come I'm running into the swamp person at the same site? So this year we had a success story, and we appreciate that. Took a while to get to that success story, but that's how you go to the right sizing a program. And then the other aspect is incentivizing it. So as we go forward in the water quality, the long-term irrigated lands program, I've asked staff at the regional level, okay, the wine grape growers, the almond board, a number of other commodities have sustainability programs. The food processors do audits. I mean, the tomato guys, if you're going to sell your tomatoes to whoever, Unilever, Walmart, require you as a grower to submit a sustainability audit. Therefore, why do we need to do, especially in low vulnerability, low threats to surface water areas, do we need to be doing comprehensive farm evaluation reports that really fill a file cabinet add to the cost of the growers to do that for data management, but really don't produce any new information. I'll stop there. Thank you very much for your time. I'm going to leave this with you. I'll leave it with staff. And thank you, Danny.
Thank you. Any comments?
No, I think just to wrap up, thank you all for your efforts to date. I think we heard some great reports and ideas today. We look forward to hearing the next update at the first April board meeting, whenever that is, 9th, April 9th. I really like the idea of the implementation plan and encourage you to incorporate, that discussion into your group as well. I particularly like my idea of putting in targets for reducing cost of compliance as part of that implementation effort. And I think all of the suggestions and ideas that I've heard today are great ones that I'd love to hear more about.
No, I really appreciate the great deal of effort that's gone into this, and I hope through my comments to really affirm your commitments to this exercise. I think we're breaking new ground in some ways, in terms of really sunshining cost of compliance and all its complexities. And I want to, in addition to looking at sort of what we might categorize as the paperwork requirements versus the brick and mortar requirements, that sort of distinction. I also want to encourage a distinction between sort of continuous low level, the costs of the program versus discrete costs that happen when, some kind of major infrastructure change is needed. That's that dimension to this question of cost. There's the low level, day in, day out average cost, and then there's these case studies where we got to move the treatment plant, or and so we can't have that lost in all this, nor can we have that skew what the costs of compliance are, because those are special cases. So I wanted to just add those dimensions or emphasize that. But I think, and I just want to really encourage this information coming to the board, because we're very interested in continuous improvement and really, encouraging that stewardship that is the majority of our stakeholders in the regulated community. Thanks.
Jeff, I know you have one question. I have one question, though. When will other stakeholders be engaged, and when will staff be more engaged in these processes? And Bobby was a participant in this. This reminds me so much of the good work that came for the recycled water policy from the stakeholder community. But there was a lot of constructive give and take, particularly with the environmental stakeholders as well, such that when the policy came through, the policy changes came through, actually we had a broad support. And by having staff engaged in some of this, and Jonathan was there, it's kind of what Bobby was alluding to. You don't go in directions that just simply are going to be hard to navigate. Maybe they do need to be on a board, but there are some things that people may want, but it's going to be real hard to go there, at least based on what we have right now. So that was something that staff contributed to the recycled water policy. So I'm just wondering when that level of engagement is going to start happening.
Well, member,
Actually, could I ask the stakeholder or the coordinators to answer that? Because if I remember correctly, there were at least one NGO signed up as an interested participant in these groups. Did any members of the NGO community participated in your discussions?
I can just say with regard to the MPDS stakeholder group, there are a couple, I think, of NGO representatives. They are going to be part of our next wave of outreach here. We haven't even reached out to our other MPDS colleagues. We've been sort of POTW focused. So when we do our write-up, we will be sharing it with the larger MPDS group, which includes the NGO representatives.
Okay.
And I would say for stormwater, I believe there's a couple of NGO representatives on our list of 170 or so. It's been hard to know who actually is on the calls, though. Sometimes people don't necessarily identify themselves, so and if they don't speak up, it's hard to know for sure. But we definitely want to involve them as well, obviously, because they've got a lot of understanding and experience we could draw on.
The WDR group will, excuse me, cheat. I'm a member of the California Roundtable on Ag and the Environment, so we'll use that mailing list, and some of my friends there reach out the next go-around. It includes NRDC, EDF, a number of people you know.
Not with the Irrigated Lands Program unless you consider the fact that the California Farm Bureau Federation is an NGO.
Just to speak to the involvement of staff, in the work plan that was presented to the board last summer, it outlined a process whereby the bulk of the work was initially requested of the discharger community within the 4 areas or subgroups that were set up. So we were looking at this as something where we were asking the discharger community to be the ones to really develop, identify the areas of where they wanted to put their effort towards recommendations. We do have a list of regional board and state board staff that we solicited to be involved as in a more or less advisory capacity for the work groups. And to the extent to which we're aware of the calls that are happening, they do participate. On the stormwater call, we had a Region 8 representative who I think was very vocal. And so the way the work plan is laid out for the next several months, the recommendations will begin to be developed, and the advisory group will then be working with the subgroups to look at issues such as are these areas that we can consider in terms of perhaps delegated authority limitations, Clean Water Act limitations, et cetera. So we'll start to provide that input and advice. And then what will come before you in the April and June timeframe will then be the work group or subgroup recommendations, and then you'll be able to engage and provide your thoughts and your direction on which elements to proceed with, and then we'll have a more involved, even more involved staff effort at that point.
I guess to add on to that, Fran, for me, the difference between this and the recycled water effort was that the recycled water effort, I was expecting to be a consensus recommendation from the group. And in this effort, at least I personally was not expecting a consensus recommendation from the regulated community, the enviros, and staff. I wanted to hear the recommendations from the regulated community through these groups, recognizing, of course, that they would benefit from getting input from the environmental community as well as from staff. But still, ultimately, what is presented to us in June should be, in my opinion, the recommendations from the regulated community, because they themselves have the information with respect to cost of compliance, and they're the one who are implementing the programs. They're the one who I think are in the best position to recommend suggestions for reducing those costs. And then, of course, there's no commitment that we implement them as is. Obviously, as Karen said, whatever is recommended to us will go through, I'm sure, multiple discussions before changes are made. But I still would expect and hope that these recommendations would come directly from the regulated community and not be a consensus type project that was the nature of the recycled water policy effort.
Jeff.
I'm sorry, just a thought occurred to me. I thought it might be a good time to ask. I was hearing some common themes across the different work groups updates, and I'm wondering, maybe this is more a question for Karen. Is there a provision or task in phase 2 to sort of compile those if there is a common theme about reporting or duplicative requirements? And because I'm thinking if you want to try and institutionalize changes, it's one thing to do them silo by silo, but it's better to do them in a more comprehensive way. Ultimately, I just wonder, is there a task to recognize those and then think about how to compile them in some sort of board-wide change?
When I recall in my head the work plan, there is not a specific task related to bringing together common recommendations across the subgroups, but that certainly is something that, just again, listening to the themes that you have all brought forward, would be appropriate to include and to move into that. And maybe we can start compiling that more formally after the April item. So based on the April item, when your recommendations are more set, we can figure out then how to track those common themes and make them available on the website so folks can feed into it.
Good question.
That was-
Thank you very much. Thank you for, it was great. As you can tell, we love it. Let's take a 5-minute break. I've had a request for a 5-minute break, and we'll come back at 11:45, and Michael will be the star witness. Thank you.
Yeah, well, no, we'd always like to see it. So, but as far as I'm concerned, I thought we dealt with construction, so I'll take a look and make sure that, it's not an issue. Right. And then we don't have federal
Okay, we will reconvene for the last item, and I don't see Tom. Okay. I think, Michael, you get to introduce yourself.
Hello, board members. Michael Wofford, Chief Counsel, and today we were going to have a brief informational item just to update the board on the implementation of Senate Bill 965, which was passed last year and represents the first real reform, if you will, well, the first legislative reform to the Water Board's ex parte practices and the prohibition on ex parte communications in many adjudicative Water Board proceedings. I'm going to start off with a very brief background. I'll try my best not to read PowerPoint slides, but all of the members of the Water Board family going back for the last 4 decades have been well versed in the issue of ex parte communications. And over the years, my predecessors had issued a variety of memoranda that generally enforced a broad concept that ex parte communications were anathema to almost all Water Board proceedings because of the transparency that we try to have in our proceedings, the need to base our ultimate decisions on an administrative record. And over time, as the scope of the issues that the boards faced and the different variety of regulatory mechanisms that they wielded became more diverse and touched more aspects of the lives, I think the chief counsels of the board have become more nuanced in their presentations of the ex parte issue. And generally, as you look at it over the last 10 years, there's been a broad dichotomy of recognition of the board's 2 primary functions, that of a judge-like function, the quasi-judicial function, and that of the legislature, a quasi-legislative function. And starting with Chief Counsel Wilson's memoranda in 2001 and 2002, the board started making that more clearly the break line between when ex parte communications are prohibited before the board, which had been a general practice through the 70s and 80s and much of the 90s, to it's only going to be prohibited in adjudicative proceedings before the board, and a recommendation from the legal office that in those legislative matters that the board undertakes, policy, regulations, planning, that while they're not prohibited, they will be allowed, but there is a recommendation for disclosure. When I became Chief Counsel in 1995, there had been a lot of discussion about inconsistency in the application of ex parte communications throughout the water boards, and I undertook an endeavor to write a question and answer document that built on the framework that had been laid out in Craig Wilson's prior memoranda, but instead was also designed to flesh out and put structure to the ex parte issue above and beyond that general legislative versus judicial dichotomy. And it was designed to solicit, well, in the initial incarnation, I solicited from throughout the Water Board family, all the regional board members and the state board, the most common issues that board members encountered in their day-to-day functions with ex parte communications. And we built that out into about a 30-page ex parte communications question and answer document. The intent being not only to provide sort of one consistent answer, but also to serve as a resource that board members could reference back to relatively easily. So that document has been in use by the water boards since 1996. It's only undergone one update prior to this past December, and that update was to address just some questions that came up and how the water boards needed to deal with issues such as matters that were being held in abeyance and there was no active request for decision from the water boards. One of the other things about the shift to the ex parte Q&A was an intent to make it more easy to update it as questions came up. And the fact that there really weren't a lot of desires for changes other than some of the overarching issues that some people find frustrating about ex parte communications. There really weren't a lot of desires to address additional issues or a need to address additional issues. However, there have been a number of people and constituents over the years that have expressed some broader frustration with what they perceive as limitations on the ability to speak to board members. Obviously, one of the strengths of the water board system is that we do rely on public meetings, and ex parte communications and the prohibitions certainly did not prevent board members from being educated about the issues, but it provided a framework in an open board meeting for you to receive those communications and for others to hear them and then subsequently be able to comment on them. Senate Bill 965 came to pass this past year. It's Senator Wright's bill that was designed to address some of the issues concerning ex parte, and ultimately where the bill ended up was that it addressed and recognized one of the board's hybrid functions. I refer to the board undertaking legislative actions where it sets broad policy and plans, but when we're talking about things like general permits, they are adjudicative in nature because they're directly enforceable. They lay out the rights and duties of parties. But when the board establishes general orders, or a regional board establishes general orders, it's really also undertaking what appears on some levels to be a quasi-legislative function, because we don't know the universe of people who will be enrolling under those orders. It may change over time. And so Senator Wright's Senate Bill 965 recognizes that there is this hybrid function, that it affects such a large swath of the regulated community when you issue a general order, and that you're not enumerating all of the parties that are subject to the order at the time that it's issued. You may not even be enumerating any of the parties. You're just providing them an opportunity to enroll. That when the board acts like that, it's appropriate to recognize a different model. And that's what Senate Bill 965 does. It establishes a new Water Code section, 13287, that only applies to general orders of the water boards. These general orders are items where all the specific dischargers are not identified in the order, but instead it provides an opportunity to enroll or file a notice of intent to seek coverage under the order established by the boards. These general orders can be either waste discharge requirements, whether they're waste discharge requirements issued solely under the authority of Port of Cologne or National Pollutant Discharge Elimination System permits. It also includes general water quality certifications and conditional waivers. Again, the attributes of all of these is that they apply very generally across our regulated community, and we don't know the universe of potential enrollees at the time the board undertakes its action. One of the issues that was discussed during the evolution of Senate Bill 965, and it's important to highlight that it's a type of permit that a lot of people seem to think of as general orders, but they're really not general orders, and that's the regional municipal stormwater permits that are issued. Often, all of the municipalities within a region will be identified in these Phase 1 permits, and I think a lot of people tend to think of those, therefore, as general orders. However, they have attributes that still put them plainly in the universe of traditional quasi-judicial actions of the board. They require the filing of a report of waste discharge, an application, if you will, by the dischargers, as well as all of the individual or all of the municipalities that will be regulated are specifically identified in the permit, and the regional board is essentially acting on the application that had been filed by those municipal permittees. This stands in contrast to, say, the Phase 2 MS4 that is pending before the State Water Board at this point in time, where there is no application filed by those Phase 2 municipalities. There are a number of exemplars that are identified in the draft Phase 2 permit pending before you. However, it does not list all the universe and identify all of the potential small MS4 permittees that it could be covered under that permit. And as a result, it actually puts in place a process for enrollment or filing a notice of intent in order to seek coverage. So for these general orders, Senate Bill 965 and new Water Code Section 13287 shifts the Water Board to a disclosure mode for certain interested persons. And in general, for those interested persons, communications are permitted with the Water Board members up until the board acts. However, there is a provision of the statute that allows a 14-day hold to be placed prior to the board's action on the general order. And it is optional at this point in time. The Office of Chief Counsel and through discussions with the executive officers and elsewhere have recommended during the transition period, at the very least, that 14-day period be put in place and that prohibition on ex parte communications occur for the 14 days leading up to board action. There are a variety of reasons that we're making this recommendation. From the temporary perspective, we're just doing it simply. You know, as you'll see as I walk through the statute, there are requirements for how quickly parties must disclose, and then an obligation on the Water Board staff to promptly disseminate and post those disclosures. And we're simply not sure at this point in time how many communications there will be under the scope of Senate Bill 965, whether we have the capacity to get them posted in a timely way. But even absent those transition issues, my recommendation would be for the boards to continue, absent extraordinary circumstances, to put the 14-day hold in place. And primarily that stems from two reasons. One, it's a transparency issue. The 14-day hold was crafted in such a way that it allows the disclosure to be made. The disclosures have to occur within 7 days of the communication with board members. And that gives an opportunity for those disclosures to occur, get posted, and be disseminated to the public prior to the board's action. So there's a transparency element to it. Without the 14-day hold, communications could be occurring the day before the board meeting. The disclosures wouldn't be required until after the board acted, and other stakeholders may have no clue about the communications and what was said, and therefore not necessarily have an opportunity to respond to them. There's another aspect of it, which is a logistical aspect from the water board's perspective, and that is during this 14-day period, that is the run-up to the board meeting when all of the various comment letters are being assimilated, the staff who would be responsible for disseminating are working on preparing their final presentations, and there simply is a capacity issue to address absent a 14-day hold.
Michael, before you move off this the slide, I have two questions. The first, is there or will there be on our website a list of the general orders for which ex parte communications are allowed, along with you know, the expected adoption date, so people know, you know, what is available?
We do not have a web page set aside for that at this point in time. I think it is a good idea, and it would be a relatively simple addition. There are not a lot of these general orders that are pending at any particular point in time, and so from a data management perspective,
I think it would be helpful to us as well as to our assistants as they're receiving meeting requests.
Excuse me. This came up in Region 4 at their retreat when they were being advised on the new ex parte rules. And one of the suggestions that was made there is that when they send out a notice on a particular hearing or workshop, that that they put prominently up, you know, toward the top what the ex parte situation is for that particular activity, and what if they have decided to do a 14-day hold, when the date of that 14-day hold, so that it's just super clear in connection to the actual activity.
No, those are excellent points, and actually just Vice Chair Spivey-Weber gets to an important point, which is basically this presentation is being presented to all the regions as an effort to assure consistency. And one of the items, we've had discussions at MCC and regular discussions over the last 3 months amongst the regional board attorneys about how we'll go about implementing this. And generally, there's the transition issue we have right now is we don't have a new notice out for some of the items that were pending on the roll of January 1 of 2013 when Senate Bill 965 took effect. However, for all the general orders that are being noticed up after this date, as hearing notices go out, there is going to be a discussion of when the applicable 14-day period would come into place, and whether or not there will actually be a 14-day hold during that proceeding. Like I said, right now my recommendation, especially during the transition period, is that we maintain that hold. And it is an excellent point about going ahead and posting on our website. We will go ahead and do that. It will be under the ex parte section on the State Water Board's website.
Before you move on, I said I had two questions. So my next one is regarding that 14-day. I mean, I personally like the 14-day because I know, for us, leading up to the board meeting or the adoption hearing, there is always so much to read, so much to consider that, you know, I can't imagine trying to squeeze in last-minute, meetings as well. But some of the concerns that I've heard from various stakeholders is that many times the staff releases proposed changes within those 14 days. And yes, I know those changes are, most often always in response to comments that were received, and staff is merely responding and making the appropriate changes. But I think the concerns from the stakeholders that I've heard is that this 14-day hold then does not give them the option to discuss with the board members those, quote, late, unquote, changes.
Okay, well, first of all, I would say that it's pretty rare that there's any kind of significant changes during that final 14 days. There are change sheets that come out, mostly in the nature of minor corrections that occur in that final 14 or 10-day period. I only say 10-day because that's the basic minimum Bagley-Keene notice. Here at the State Board, we tend to exceed that a fair bit. At some of the regions, they may push up closer to the 10-day. But the second point that I would have to that is the more fundamental point, which is there is not a denial of the opportunity to comment on those changes. That opportunity will occur at the board meeting when everyone has an opportunity to hear the stakeholders' concern with the changes and recommendations for how to address it. And likewise, the other stakeholders have an opportunity to hear it and comment on those changes. So, you know, this is an extra tool that's available for stakeholders to meet with board members for the class of orders that are general orders. And you know, at this point in time, given the fact that there is still that public process at the board meeting, an opportunity for comment, an opportunity for response, the recommendation from my perspective is that the 14 days is a small price to pay in order to provide that orderly run-up to the board meeting.
I would add, it's an option for a 14-day hold. Let's give it a try. Doesn't work, let's revisit it. It's easy enough to revisit.
And I should also say the 14-day sorry about that. That was my fault. Janine may cut me off at times. I should mention, with respect to the 14-day hold period, as you all are aware, there are times that items come before this board and end up getting continued. The way that Senate Bill 965 is written is that provided that it's continued beyond 14 days, which often you all choose to do that, to allow additional stakeholder input, allow staff to address your comments or concerns, the prohibition on communications lifts when that continuance occurs, but then can be put back in place in the 14 days before the final the next action point, if you will, by the board. So it's not as if it becomes a monolithic prohibition on ex parte communications for the remainder of that proceeding. You know, a great example of that would be the general industrial permit, which you've heard workshopped at various points in time, and we've had different paths for adoption on, and communications would, under Senate Bill 965, even with a 14-day hold, be a live opportunity for comment directly to the board members and subject to the disclosure requirements of Senate Bill 965 now. With respect to how far Senate Bill 965 reaches and what how it defines ex parte communications, it largely tracks the existing definition that the board members use and are familiar with out of the Administrative Procedure Act. It concerns written or oral communication, so that when we look at that, that's phone calls, emails, any form of communication really with the board members. It's important to understand that while it creates a special exception for these general orders that allows some meetings to occur with board members subject to disclosure requirements for interested persons, it doesn't change any of the other substantive bodies of law that concern the board and board action, such as serial meetings. You know, you can't use intermediaries, whether within or without of the water board, to reach a collective decision. And it's important to understand that ultimately the board needs to act on the record that's before it, and so you need to be sensitive to this is an opportunity for persons to communicate with you and for you to ask questions of those persons, but they're still going to need to get their comments on the record at a board meeting, and it's important that you recognize that all the requirements of basing your decision on the proceeding and on your own opinions still apply. As I indicated, our expectation is that the actual hearing notice will specify how things like the 14-day hold go in place, and that this particular pending proceeding is subject to the special ex parte disclosure requirements associated with Water Code Section 13287. But that same hearing notice also specifies how people submit comments, whether oral comments or written comments that they want to be considered as part of the record, and how they should go about submitting evidence that is designed to support their contentions and positions. The the opportunity for meetings with individual board members does not circumvent or undermine the need for interested persons to get the necessary written and oral comments into the record so that there is an appropriate basis for the board to ultimately act on the decision. Senate Bill 965 also includes very specific requirements on who's required to make disclosures. In other words, who the special disclosure requirements and the special exception to the general prohibition applies to. It applies to potential enrollees. The classic case is this is somebody who is either, or their representatives, who is going to have to enroll under the action that is pending before the board. It also extends to persons who have a financial interest in the proceeding. There may be times where, because of the way that the particular general order works or operates, there may be parties that are not specifically regulated by it who will nonetheless have a financial interest. In this context, financial interest is governed by the definitions in the Political Reform Act. And therefore, because of that financial interest, Water Code Section 13287 will require them to make a disclosure as well. And then representatives acting on behalf of an organization. Classic case in this case would be famous NGOs such as the California Farm Bureau Federation or Natural Resources Defense Council. Anyone who is representing an organized civic group, trade association, organization, and when they submit those comments to you or attempt to meet with you on behalf of that organization, then they are considered an interested person for purposes of the Water Code. Now, I have to say, the legislature didn't define this in the updated question and answer document. We give some signposts that board members can use to try to suss out whether or not somebody is actually there on behalf of an organization. Obviously, if they've submitted written comments on behalf of that organization, it's safe to assume they're a representative. But there are other questions you can ask, such as whether or not they have been asked to speak on behalf of the organization, whether the organization has already staked out a position within the proceeding, and whether or not the specific individual has been explicitly authorized by other representatives within the organization to appear. And I think this is one area where, basically if they invoke the name of the organization, the more cautious approach is to go ahead and disclose, because if an entity or an individual who meets with a board member is not in one of these categories, in other words, is not an interested person, then Water Code Section 13287 imposes no reporting obligation on the individual. A good case of this, and one that board members may be familiar with, are representatives of the legislature who may simply be reaching out to the board to express interests of their constituents. And in those instances, the legislator or the legislator staff is not an interested person, and there is no disclosure requirement under Water Code Section 13287. In the interest of transparency, the board member may choose to make a disclosure at the board proceeding. But there is no legal obligation for disclosure in that context.
And does that also apply to, say, a regional board member or a member of another state agency?
There are times, for example, Caltrans would be a good example, where if a Caltrans representative wanted to meet with a board member on something that they were potentially going to be regulated by under that general order, they would be considered a potential enrollee, for example. There are other instances, though, where other state agencies, or including the regional boards, would not fall into any of these categories. I think there are there are instances where we are recommending that nonetheless, for example, the regional boards go ahead and prepare those disclosure requirements. One non-obvious result of the definition of general order I was reading earlier is that the petition process before the State Water Board involving challenges to a general order issued by a regional water board is subject to the special provisions of Water Code Section 13287 as opposed to the prohibition on ex parte communications. And so in those instances, the regional board, as the entity that had issued the permit, would not, or the general order, would not necessarily fall into any of these categories here. However, in those circumstances, we are advising the regional boards to submit the disclosure requirement, the required disclosures under Water Code Section 13287. And that, you know, frankly, is an issue that as we go forward with the implementation of Water Code Section 13287 may be an area appropriate for minor legislative fixes. And I say that because there are other examples of where persons could petition the State Water Board on general orders issued by a regional water board, and it would not, the person who actually filed the petition may not fall into any of the categories identified in Water Code Section 13287. So in the interest of transparency, we'll continue to recommend disclosure in those circumstances, and if it becomes necessary, we may discuss with the board members whether or not the administration would be interested in a legislative fix. So who is responsible and how do we actually handle the mechanics of reporting under Water Code Section 13287? At this point in time, Water Code Section 13287 requires the interested person to make the disclosure. That is the model that was used by some of the other agencies. You may hear either from commenters today or see references because Senator Chesbrough last year, when Senate Bill 965 was making its way through the process, recommended that perhaps it should be the board members who make the disclosure. That's a fair discussion to have, I think, given the system that the water boards have, where we have dozens of regional board members who are volunteers, and if they are required to do the reporting requirements, I have real concerns about the needs and capability that they have, considering all the other time commitments they already make for the water boards, and whether or not if they were forced to do the disclosure, you'd end up in a situation where they just found it easier not to meet with interested persons on pending general orders. So the disclosure obligation falls on the interested person who communicates with the board member. The legislation is very specific about the types of things that need to be disclosed, such as who was present at the meeting, where the meeting occurred, the topics that were discussed, which board members were present. And because they are so specific, we don't feel the need to establish our own forms at this point in time. However, to assist the public, we've made forms available on the State Water Board's website. They've also been posted up on all of the regional board websites. This is a form that's designed to facilitate the disclosure. It includes all the statutory requirements. However, it's optional. Somebody could file a necessary disclosure simply by submitting a letter to the water board that satisfied the disclosure requirements. Key question that comes up, and it's actually a question that interfaces with the first question of who is responsible for disclosure, has to do with what to do if the disclosure is inadequate. In the updated question and answer document, I recommend that whenever a board member is going to be meeting with an interested person about a pending general order, that they request that an agenda be prepared as well as any talking points be provided, and that will help provide some record of what was actually discussed, and it will actually facilitate the interested person's disclosure of the communication. If the disclosure is inadequate, our initial recommendation is for the board member and any staff that would have been present with the board member to reach back out to the person who submitted it to get the additional information and to get them to solicit or to provide the necessary disclosure information. If for some reason the person chooses not to, or time is short, even with the 14-day window, and the fact that these disclosures have to come in 7 days after, within 7 days of the communication occurring, the board members may feel it necessary to actually correct the record or to supplement the record at the board action and disclose any additional information that was not included in the written form. By statute, when the water board, these forms must come in within 7 days of the ex parte communication on a general order. And when they come in, the water board staff are required to post them up on the relevant web page. This will be under the program web pages. And in most instances, what I anticipate we'll see is a bullet point on the web page, for example, on the pending Phase 2 MS4 permit, that would just be a hot link of ex parte communications, disclosures pursuant to Water Code Section 13287. And then in addition to posting on the website, the legislation requires that the board disseminate the notice on the LIRIS list for the pending item. So just in the interest of efficiency and trying to avoid the water boards becoming people's least favorite spammers, what we will try to do is roll up any ex parte disclosures. The obligation is on us to promptly post and promptly disseminate. And assuming that we do a good job getting items up on the website, more likely the notices that will be going out on the LIRIS list will simply be that there have been ex parte communication disclosures as required by Water Code Section 13287. Those disclosures are available at the following URL, and then that way people can go there and see them all rolled up in one place rather than seeing multiple emails. So we recognize, and it's been my commitment ever since I became chief counsel, and the ex parte issue was brought front and center by a number of stakeholders early on in my tenure, the need to have consistency and to get information out to all of our board members in a timely and consistent way. The updated question and answer document on ex parte communications was posted up on December 28th. And the model disclosure forms that could be used for individuals who need to make required disclosures under Water Code Section 13287 were posted up on the State Water Board's ex parte page on December 31st of this year. The regional water boards, as of today, I believe all of them have under their publications and forms link their own model forms that are modeled off the State Water Board's forms for disclosure. And I mentioned earlier in response to Vice Chair Spivey Weber's question that we actually are going around to all of the regional water boards, some at their annual retreats, others as part of their regular scheduled board meetings. I believe Board Member Dodek had an opportunity to see this presentation presented to the San Francisco Bay Water Board recently. We also did a comprehensive overview of the changes wrought by Senate Bill 965 at this past fall's Water Quality Coordinating Committee meeting. So we're doing our best to make sure that people are on the same page with how this bill will be implemented, and we're trying to make it a new tool for communicating with the water boards in appropriate circumstances. And if you have any questions, I'm happy to take them now.
No, I wanted to thank you and staff for working over the holidays, though, to meet that January 1st deadline. I guess, I'm a little concerned that ex parte communications would be red flagged in the emails. I mean, I know you're working through that, and I know we'll refine this, but yeah, to have a separate communication go out that, red light flashing, there's been ex parte communication, to me it skews the process a little bit. It would, I would be more comfortable if it were just nested within the package itself that would go out. It's obvious you're struggling with that.
Yeah, I think that's part of the challenge is this is getting bolted on to a process, and you want to ensure not only to carry out the plain language of Senate Bill 965, but I think also for those of us who appreciate the transparency of decision making that the water boards have, you want to make sure that people get timely notice of ex parte communications so that they have an opportunity to respond or rebut and to shape the comments that they may present at a state water board meeting. And so you're not going to be sending it out necessarily with the packet of materials that most people will rely on. These are, by definition, now going to be following some of those. But, we will certainly work. This is going to be a learning curve for us. I think, the Regional Board Council, myself, the program staff who've been involved are trying to make sure that this is functional and effective. And if we need to retool as we implement Senate Bill 965, we will do that. And if we need to have a larger discussion about whether or not the frameworks in it work, we're not shy about having that conversation.
I appreciate it. Thank you for clarifying.
And just to reiterate something I mentioned earlier, on those, particularly on those things where ex parte is in place, I think that needs to be in the notice as well, because there is lots of room in the transition period for confusion, and so this is an opportunity to educate people that, what is and what isn't in the system.
Okay.
I don't have any other questions. Thank you very much. Tom, we now have the rest of the afternoon for the Executive Director's report. So just go ahead and get started. Take as long as you want.
But
Well,
you
I
are
guess you have-
standing between us and lunch.
Yes, you have a choice between the executive director's report and lunch, and I know where I stand in the order of things. I don't really have anything other than what's in the report itself, and so I encourage you to read it. And if you have any questions, happy to answer them. If not,
Thank you. Then the meeting stands adjourned.